Hello and welcome to Inside Edition to discuss national, regional and international issues in depth. In recent years, Bahrain has witnessed comprehensive development combined with accomplishing remarkable achievements on various aspects. Arbitration is one of the vital fields in which Bahrain exerted tremendous efforts to promote its status as a regional hub for arbitration. In 2015, Bahrain enacted legislation adopting the United Nations Commission on International Trade Law, specifically the Model Law on International Commercial Arbitration for both international and domestic arbitration, enhancing an already arbitration-friendly legal system. To discuss this matter, we are joined today by the Chief Executive Officer of the Bahrain Chamber for Dispute Resolution, in short BCDR, Professor Nassib Ziadé, who has extensive senior managerial experience in the administration of international legal proceedings and the development of international tribunals, in addition to being an expert in private and public international law, international arbitration, international investment law, international administrative law, and the law of conflicts of interest. Welcome back. Joining us in the studio is Professor Nassib Ziadé. Thank you very much for being with us today.
Thank you for inviting me.
Professor Nassib, first of, the great importance of arbitration and dispute resolution led to the establishment eventually of the Bahrain Chamber for Dispute Resolutions, in short that's BCDR. Tell us more about the importance as well as the Chamber's main missions and organizational structure, please.
Well, when cross-border disputes arise, you need to have in place an efficient, cost-effective, and neutral dispute settlement mechanism, allowing such disputes to be resolved. Now, it is always preferable if parties to an international dispute can settle their differences themselves. But very often this may not be possible, and an impartial third party may be needed. Now, before the parties embark on arbitration or litigation, they may try to resolve their dispute by some form of alternative dispute resolution, such as mediation or conciliation. And the mediator or the conciliator will try to enable the parties to reach a compromise agreement. Now, if the dispute cannot be settled by the parties themselves or by a mediator or conciliator, then arbitration will be the most effective way of obtaining a final and binding decision on the dispute without recourse to a court of law. Now, you asked me about the Bahrain Chamber for Dispute Resolution. The Bahrain Chamber for Dispute Resolution is, as you know, a regional dispute settlement institution. It has been in operation since 2010. It was established by royal decree in 2009. And it is in partnership with the American Arbitration Association, the AAA. Sometimes it's being called BCDR-AAA. Now, BCDR provides commercial and governmental parties contracting in the region with solutions for rapid and effective resolution of commercial, investment, and financial disputes. Now, its structure. The chamber consists of a secretariat which is overseen by a board of trustees, BOT. Now, the BOT comprises 8 members, Bahrainis and non-Bahrainis, and is being chaired today by Sheikha Haya bint Rashid Al Khalifa. As you know, she's a former chair of the General Assembly of the United Nations. Now, the secretariat operates under the direction of the CEO, and it includes a chief registrar and a number of trained experts in the field. Now, I have served as CEO since 2013, and my colleague Ahmed Hussein has been the chief registrar since 2010. Now, the BCDR's case management team is composed of lawyers, Bahrainis and non-Bahrainis again, who are fluent in Arabic, English, and French. And our lawyers and case managers undertake continuing professional development.
Well, that's a beautiful diversification, diverse hierarchy. And this diverseness is important, isn't it?
Yes, it is very important. Unfortunately, we do not see today in the field of international arbitration as much diversity as we wish to see, but we are working very hard on diversity, not only in terms of staffing, but also in terms of having arbitrators come from more diverse backgrounds.
Perfect. What are the advantages when it comes to arbitration?
Well, Sarah, there are many advantages associated with arbitration, which explains why parties today to international disputes prefer to go to arbitration rather than to an established national court. Now, the first advantage is neutrality. Parties to an international contract usually come from different countries. And international arbitration will allow these parties to avoid having to refer their dispute to the national courts of one of the parties and to choose instead a more neutral tribunal. This would create procedural fairness to all parties. So that's the first advantage, neutrality. The second advantage of arbitration is that it gives each party the opportunity to participate in the selection of a tribunal. So typically, if the tribunal consists of a single arbitrator, that single arbitrator will be chosen by agreement of the parties. Now, if the tribunal consists of 3 arbitrators, 2 of them may be chosen by the parties, and sometimes also the parties may have a say in the choice of the third arbitrator, the chair of the tribunal. The third advantage of arbitration is flexibility. Now, as long as the parties are treated fairly, and this is very important, due process is very important in arbitration. As far as the parties are treated fairly, the arbitration can be tailored to meet the specific requirements of the dispute. And the arbitration does not need to be conducted in accordance with a fixed and invariable set of procedural rules which apply in state courts. Now, the fourth advantage of arbitration is confidentiality. Parties to an international commercial dispute may wish to avoid the risk of their dispute attracting adverse publicity. And this is impossible when the dispute is referred to national courts, because before national courts, proceedings are generally public. Now, by contrast, arbitration will allow the proceedings to remain private. And the confidentiality that surrounds this process is a very strong incentive for companies and individuals who are involved in international legal proceedings. Now, in recent years, I have to say that confidentiality has eroded in some forms of arbitration, such as investment arbitration, but still confidentiality remains an attraction of international arbitration.
Arbitration being in a private setting is basically the main difference between it and legislation when it comes to that fact. Well,
different with the national courts.
Yes, exactly. When we talk now about the BCDR-AAA, as you said, what makes it different than its counterparts in the same field, within the same field?
Well, we place great emphasis on quality. And we make every effort to ensure that our rules and our procedures correspond to the best international practices. I give you an example. In 2015, Bahrain enacted legislation which adopted the ancestral model law on international commercial arbitration. Law on international commercial arbitration will extend to both domestic and international disputes. Now, following the enactment by Bahrain of the ancestral model law, the BOT of the BCDR entrusted a 3-member review committee composed of Antonio Parra, a former Secretary General of ICSID, Adrian Winstanley, a former Director General of the London Court of International Arbitration, and myself, with the task of drafting revised arbitration rules for the BCDR. Now, how did we do our task? We first reviewed all the existing sets of rules of leading international and regional institutions. And we also reviewed the 2010 ancestral arbitration rules. And we drew up draft rules embodying the best standards in international arbitration. So we took elements from all the existing rules there. Then we requested feedback from current and potential users before we submitted the draft rules to the BOT for its final adoption. Now, our new arbitration rules are available in English, Arabic, and French, and all 3 versions being equally authoritative. Now, the original draft rules were drafted in English, but how did we come to the other versions? I don't send them to translators. I don't leave anything to chance. I sat with experts, with a gentleman who has a PhD in international law, with a law professor of civil and private international law, and the 3 of us drafted the rules in Arabic and French. And to quote Adrian Winstanley, my colleague, he said that the new BCDR rules are the equal of any other and superior to many. Now, we are keeping the same momentum by now revising our mediation rules and by creating our own investment arbitration rules. So the same process will take place. Now, also, our case management team is composed, as I said, of lawyers who are fluent in Arabic, English, and French. and we are hiring lawyers with international exposure to administer our arbitration cases and work on our other recent activities.
Yes.
In addition, we produce an international law journal and other scholarly publications which are unmatched in the region. I have also to say that the BCDR has state-of-the-art hearing and meeting rooms, video conferencing resources, and on-site technical support.
Yes.
So you see what makes our difference
Yes.
from the others.
Yes. And of course, these differences are what help at the end to have, as you said, due process or give due process to the clients that are basically coming to you. After a year of bringing the amended rules, the ones you just mentioned, into effect, following substantial revisions to the previous law in Bahrain, the ICAL of 1994 included full incorporation of the UNCITRAL or the UN Citral model law. We mentioned it also in the introduction. How do you value the implementation of these modern and advanced set of arbitration rules?
Well, in my view, Sarah, Bahrain today offers ideal conditions, and I measure my words, for holding international arbitration proceedings. First, as I said, in 2015, Bahrain adopted a very liberal law on arbitration, which applies the UNCITRAL model law on international commercial arbitration to both domestic and international disputes. And I take no credit for this. I was not consulted, and they did the right thing. In addition, Bahrain is a party to a number of international arbitration conventions, which would facilitate the recognition and enforcement of arbitral awards. These include the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards, which Bahrain ratified in 1988. The GCC Convention for the Execution of Judgments. The Riyadh Convention on Judicial Cooperation between the Arab states of the Arab League. The Washington Convention on the Settlement of Investment Disputes between states and nationals of other states, the Exit Convention, that was ratified in 1996 by Bahrain. So we have all these conventions ratified by Bahrain. We have this law which is enacted by Bahrain. On top of this, a year ago, the BCDR adopted comprehensive, universally applicable and state-of-the-art arbitration rules, which contain innovative provisions, including on such matters as expedited, summary, and emergency arbitration procedures. So there is no question in my mind that Bahrain and the BCDR are today well placed to host arbitration proceedings and to ensure procedural fairness for the parties.
The BCDR is basically a forefront and a template for how the proceedings should be when it comes to arbitration. Now, the Bahrain Chamber for Dispute and Resolution places very high priority when it comes to developing awareness in international arbitration for regional practitioners, as you mentioned, and to conduct training courses and feature experts in the field of arbitration. What can you tell us about these efforts?
Well, the BCDR views training and educational opportunities as an integral part of its mission. Now, first, it holds training sessions and workshops on arbitration and mediation for judges, lawyers, in-house counsel, experts, and students. It also supports the training of law students interested in international commercial arbitration, and we need to educate the new generation of arbitrators. We take great pride in this. Now, in addition, BCDR holds regularly conferences on arbitration. Recent events have included the biennial conference of the International Federation of Commercial Arbitration Institutions, a conference on international investment arbitration in the MENA region, the fourth conference for a Euro-Mediterranean community of international arbitration, which was held in conjunction with the UNCITRAL and the OECD. All these conferences were held in Bahrain. And BCDR also joined with the International Council for Commercial Arbitration, the ICA, in organizing some years ago a roundtable on the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards, and were able to bring judges from the appeal courts and courts of cassation of 13 Arab states. So for 2 days, they sat together and they discussed how they can reach a consistent application of the New York Convention in front of their courts. Now, also very importantly, BCDR produces a biannual law journal, which is called the BCDR International Arbitration Review. And this journal contains articles and case decisions in Arabic and English. each issue of the journal focuses on one specific topic that is timely and relevant to the Arab region.
Yes.
And I can give you examples of previous issues. We had an issue on the recognition and enforcement of foreign arbitral awards in the Arab states of the Gulf.
Okay.
We had 2 issues of on women's voices in international arbitration.
Yeah.
So we invited exclusively women in the field, and we invited them to contribute to articles. And to the best of my knowledge, no one, neither in the region nor in the West, have done this before.
Yes.
We had an issue on arbitration in Egypt. We had an issue on investment arbitration in the Middle East.
Yes.
We had an issue on construction arbitration in the Middle East.
Mm-hmm.
And the review has received very positive feedback from legal experts in the field.
Yes.
Now, in addition to the BCDR, to the review, BCDR has also launched a series of publications honoring Arab scholars and practitioners who have promoted international arbitration and international law. Rather than to wait for Western institutions to honor our practitioners and our scholars, we do this ourselves in Bahrain.
Perfect.
We have so far honored Dr. Ahmed Al-Koshairi, who is a leading Egyptian international arbitrator and lawyer. And we are in the process of preparing another book to honor Samir Saleh, who was the first Arab vice chairman of the Court of Arbitration of the International Chamber of Commerce.
Yes.
And each such book consists of scholarly essays written by leaders in the field.
Marvelous. I still want to a little bit to elaborate on that point when it comes to recent arbitrations and the laws of recent arbitrations, as well as the training process. Do actually the challenges that are facing the region come into perspective when you are teaching or training the new arbitrators or legal individuals? I mean, does it affect how the laws are updated and so on? Like recent
yes,
measures.
the laws are updated not because of challenges in the region. Also, you have developments that occur
Yes.
everywhere,
Yeah.
and of course we take them into account. This is what we did when we enacted our legislation on arbitration in our rules last year. We introduced some novelties such as I said, summary proceedings,
Yes.
emergency arbitration procedures.
Yes.
And similar rules which we found in rules adopted by other institutions.
Perfect, perfect. Well, the Bahrain Chamber for Dispute Resolution luncheon for senior members of the Bahrain business and legal communities opened recently, during which the Chamber's CEO, Dr. Nassib Ziadé, delivered a speech in which he affirmed that the Chamber is currently preparing revised rules of mediation and new rules specifically for investment arbitration. He said the Chamber will continue to develop its training program in arbitration and mediation and is to hold a regional and international arbitration conference in Bahrain. It will also continue attending and contributing to the work of the UNCITRAL working groups, particularly with regard to the meetings of the third working group on the reform of the investor-state dispute settlement system. He went on to say that the advantages are obvious and the location is convenient, as well as owning a state-of-the-art arbitration rules and reasonable fee structure, which has been recently revised. Bahrain has modern legislation favorable to arbitration and a supportive judiciary.
Well, everywhere, everyone wants disputes to cost less to resolve. First of all, they don't want to have a dispute, but if they do have a dispute, they want something very efficient. You know, business gets more efficient, and the law doesn't always keep up with where business is, efficiency-wise. So I think our challenge is really to bring efficiency to resolving disputes. Fair, it has to be fair. And it has to be efficient, or a business doesn't have a use for it.
This is a luncheon that we had as an initiative to communicate and to have some sort of a discourse with the business community and the legal communities and the law firms here in Bahrain. We introduce our latest activities in regard to the rules that we have, the new rules that we have in arbitration, and the latest trends and activities that we're gonna have in the future, in the near future.
Welcome back. Professor, the Kingdom has recently hosted the Bahrain Chamber for Dispute Resolution, launched on 4 senior members, as we have seen, of the Bahrain business and legal communities. Many experts in this field took part in it. Can you tell us more about the issues discussed during the sessions and the main recommendations that were suggested later on?
Yes, BCDR hosted the luncheon, and it brought together over 80 senior members of the Bahrain business and legal communities in the presence of members of the diplomatic representations in Bahrain and government representatives. It was an opportunity for us to update the attendees on the recent activities of the BCDR. And we were joined at the event, as you said, by the president of the American Arbitration Association, India Johnson, and the former Director General of the LCIA, the London Court of International Arbitration, Adrian Winston. And both of them came from the US and from England to be with us at this event. Now at the luncheon, of course, we discussed our work on the cases and our outreach activities and publications. And we provided the attendees with 3 recommendations. First, we said for parties who are located in the region and who wish to include arbitration clauses in their contracts, we advised them to consider BCDR as the administering institution. And the advantages are obvious. As you said, the location is great. We have case managers who are able to administer cases in Arabic, English, or French. We have state-of-the-art rules, state-of-the-art arbitration rules. We have a reasonable fee structure, which has been recently amended. And Bahrain has modern legislation favorable to arbitration and a friendly judiciary. It has also ratified international conventions on arbitration. Now, that was the first recommendation for the attendees, for members of the legal and business communities, to insert arbitration clauses in their contracts, referring to the BCDR. The second recommendation we made was, you know that the BCDR holds occasionally regional and international conferences in Bahrain. And we stressed that it is important for members of the business and legal communities to attend and participate in such events, because the active support of the members of the business and legal communities is critical for us in order to allow us to continue holding these events in Bahrain. And the third recommendation, we emphasized to them that BCDR needs the support of the business and legal communities with respect to our outreach activities, and especially the BCDR International Arbitration Review. The publication, which is unmatched in the region, has attracted international recognition, but interest in it remains limited in Bahrain. And we encouraged the business and legal communities to subscribe to this publication and to actively promote it in the region.
And more information on this would be found on the public websites.
On the BCDR website,
All right. How does the Bahrain Chamber for Dispute and Resolution assess its constant success, and what are its indicators?
Well, you know, arbitral institutions in general can measure their performance with respect to administrative efficiency, cost effectiveness, and neutrality. And we use statistics and informal meetings with our users. Now, it is obvious to me that BCDR has acquired regional and international recognition. There has been first a very positive response locally, regionally, and internationally to our new arbitration rules. And we understand that our model arbitration clause has been included in many contracts in the region. Now, second, our caseload is growing steadily. To date, BCDR has administered a total of 235 cases with a combined value exceeding $4 billion. So the numbers speak for themselves.
Of course.
And our journal, the BCDR's law journal, the BCDR International Arbitration Review, is internationally recognized and universally accepted as a leading scholarly publication. And the most senior members of the international arbitration community regularly contribute to this publication and to our other publications. And in a way, isn't my presence on TV an indication of BCDR's success?
Of course. Thank you very much for being with us today, Professor Nassib Ziadé, and for answering most of our questions. I mean, if we keep on talking about this, there will never be enough time. Hopefully, you guys have an event coming up, and hopefully after that we will be able also to talk more about this topic and maybe have new information on it. I would also like to thank you, dear viewers, for watching us, and see you next week in another episode of Inside Edition.